Singapore's approach to data protection is governed by the Personal Data Protection Act of 2012, PDPA, which was further amended by the Personal Data Protection Amendment Act 2020. This legislation is designed to protect individuals' personal data against misuse by regulating the proper management of personal data in organizations. The Act delineates responsibilities of organizations while also bestowing rights upon individuals regarding their personal data. Moreover, the PDPA has extraterritorial applicability, indicating that it applies to organizations engaged in the collection, use, or disclosure of personal data within Singapore, regardless of whether the organization has a physical presence in Singapore. Definitions and scope. The PDPA defines personal data broadly as data, regardless of its truth, about an individual who can be identified from that data, or from that data in conjunction with other information to which an organization has or might likely have access. This includes data of individuals who have been deceased for 10 years or fewer. Business contact information is exempt from the Act's provisions, provided it is used solely for business purposes. However, the PDPA covers business contact information supplied by individuals in their personal capacity or for mixed purposes. Data protection obligations. Organizations are obligated to make public their data protection policies, practices, and complaints process. They must also cease to retain personal data, or anonymize it, when it is no longer necessary for any business or legal purpose. Furthermore, organizations are required to respond to requests by data subjects under their statutory rights. Data intermediaries. Data intermediaries, which process personal data on behalf of another organization, are exempt from most of the data protection obligations under the PDPA. However, they are directly liable for obligations related to the protection and retention of personal data. Transfer of personal data. When disclosing or transferring personal data to onshore third parties, organizations must ensure they have obtained the individual's consent. The Act also imposes restrictions on transferring personal data outside of Singapore, requiring organizations to ensure that the receiving party has in place comparable protection to that established by the PDPA. Enforcement and compliance. The Personal Data Protection Commission, PDPC, is responsible for the enforcement of the PDPA, including issuing directions to organizations for non-compliance and imposing financial penalties. Notably, new criminal offenses have been introduced for egregious mishandling of personal data. Recent developments. Significant amendments to the PDPA introduced in 2020 include enhanced frameworks for data breach notification and increased financial penalties for non-compliance. These amendments reflect Singapore's commitment to ensuring robust data protection standards and practices. Conclusion. Singapore's PDPA represents a comprehensive approach to data protection, balancing the need for organizations to manage personal data with individuals' rights to protect their personal data. The continual updates and amendments to the Act demonstrate Singapore's adaptability to the evolving digital landscape and its challenges in data protection.